The news here today is that the court has asked the lawyers of Richard De La Sky to refile their injunction application essentially. And as we were explaining earlier, this is born out of two separate applications that were filed before the Supreme Court. The first application was asking the Supreme Court to give permission to lawyers of Richard De La Sky to amend the release on their motion for interlocutory injunction. Essentially, what they were asking the court to do was to say that the reliefs, which are things that usually the plaintiff will ask, directives that the plaintiff will ask from the court, they were not worded appropriately, and so they wanted the court to grant them leave to amend same. The second application was for them to file a supplementary affidavit in support of their application for the interlocutory injunction. Now, what has happened here is that so they filed an affidavit which basically are facts that were deposed to by Richard De La Sky as to why the Supreme Court should injunct the Parliament of Ghana from transmitting the anti-LGBTQ bill, which has been approved and has gone through all parliamentary processes, to the president, and to further injunct the president from even considering that bill and assenting to same until the final determination of the matter. Now, for the first application, lawyers from the Speaker of Parliament opposed that application. The argument that were raised by Thaddeus Sori, who represented the Speaker of Parliament, was that if you look at case precedents of the Supreme Court, if reliefs have been opposed to, the person who filed those reliefs do not have the luxury of amending those reliefs. However, lawyers for the applicant opposed this, saying that if you consider Order 16 of the High Court rules, it gives a right to any party in a case to amend their processes. The AG supported Richard De La Sky on this matter, arguing that if you look at the two set of reliefs, that is the old relief and the new relief that they are seeking to present now, they do not present anything different when you look at the material facts of it. The court then listened to the argument of or the court agreed to the arguments of the applicant, that is Richard De La Sky, and that of the Attorney General. For the second application, which is the supplementary affidavit in support of the application, the lawyers of the Attorney General, he noted that what the applicant had done, that is Richard Sky had done, was alien to law and was offensive to the rules of court, because a careful look at the affidavit, the supplementary affidavit in his view, includes points of law and matters of law and is argumentative. And he argues that the rules of court does not allow for facts that, for an affidavit that is deposed to be argumentative or to raise points of law.